Some of those watching tonight may be new to Federalist Society events and may have heard a lot of misinformation about the Society. It holds events like this convention, at which issues are debated and discussed openly and civilly. The best law school deans have expressed appreciation of the Society's contribution to free and open debate. My colleague Elena Kagan is a prime example. When she was the dean of Harvard Law School, she spoke at a Federalist Society event and began with these words: "I love the Federalist Society." After some applause, she repeated, "I love the Federalist Society." Pause. "But you are not my people." That is a true expression of the freedom of speech that our Constitution guarantees and that we need to preserve. We should all welcome rational, civil speech on important subjects, even if we do not agree with what the speaker has to say. Unfortunately, tolerance for opposing views is now in short supply in many law schools and in the broader academic community. When I speak with recent law school graduates, what I hear over and over is that they face harassment and retaliation if they say anything that departs from the law school orthodoxy. I want to express appreciation to the many judges and lawyers who stood up to an attempt to hobble the debate that the Federalist Society fosters. A move was afoot to bar federal judges from membership in the Society. 4 Court of Appeals judges, Amul Tharpar, Andy Oldham, Bill Pryor, and Greg Katsas, prepared a letter that devastated the arguments of those who wanted to ban membership. The letter was signed by more than 200 judges, including judges appointed by every president going back to President Ford. And at least for now, the proposal is on hold. We should all express our thanks to these defenders of free speech. We have never before seen restrictions as severe, extensive, and prolonged as those experienced for most of 2020. Think of all the live events that would otherwise be protected by the right to freedom of speech: live speeches, conferences, lectures, meetings. Think of worship services. Churches closed on Easter Sunday. Synagogues closed for Passover and Yom Kippur. Think about access to the courts or the constitutional right to a speedy trial. Trials in federal courts have virtually disappeared in many places. Who could have imagined that? We had a COVID-related case from Nevada, so I will take the Nevada law as an example. Under that law, if the governor finds that there is, quote, a natural, technological, or man-made emergency or disaster of major proportions, the governor can perform and exercise such functions, powers, and duties as are necessary to promote and secure the safety and protection of the civilian population. To say that this provision confers broad discretion would be an understatement. Laws giving an official so much discretion can, of course, be abused. And whatever one may think about the COVID restrictions, we surely don't want them to become a recurring feature after the pandemic has passed. All sorts of things can be called an emergency or disaster of major proportions. Simply slapping on that label cannot provide the ground for abrogating our most fundamental rights. When the constitutionality of COVID restrictions has been challenged in court, the leading authority cited in their defense is a 1905 Supreme Court decision called Jacobson versus Massachusetts. The case concerned an outbreak of smallpox in Cambridge, and the court upheld the constitutionality of an ordinance that required vaccinations to prevent the disease from spreading. It's important to keep Jacobson in perspective. Its primary holding rejected a substantive due process challenge to a local measure that targeted a problem of limited scope. It did not involve sweeping restrictions imposed across the country for an extended period. And it does not mean that whenever there is an emergency, executive officials have unlimited, unreviewable discretion. It pains me to say this, but in certain quarters, religious liberty is fast becoming a disfavored right. And that marks a surprising turn of events. Consider where things stood in the 1990s, and to me at least that does not seem like the Jurassic Age. When a Supreme Court decision called Employment Division versus Smith cut back sharply on the protection provided by the Free Exercise Clause of the First Amendment, Congress was quick to respond. It passed the Religious Freedom Restoration Act, RFRA, to ensure broad protection for religious liberty. The law had almost universal support. In the House, the vote was unanimous. In the Senate, it was merely 97-3, and the bill was enthusiastically signed by President Clinton. Today, that wide support has vanished. When states have considered or gone ahead and adopted their own versions of RFRA, they have been threatened with punishing economic boycotts. Some of our cases illustrate this same trend. Take the protracted campaign against the Little Sisters of the Poor, an order of Catholic nuns. The Little Sisters are women who have dedicated their lives to caring for the elderly poor, regardless of religion. They run homes that have won high praise. Despite this inspiring work, the Little Sisters have been under unrelenting attack for the better part of a decade. Why? Because they refuse to allow their health insurance plan to provide contraceptives to their employees. For that, they were targeted by the prior administration. If they did not knuckle under and violate a tenet of their faith, they faced crippling fines that would likely have forced them to shut down their homes. Here's another example from our cases. The state of Washington adopted a rule requiring every pharmacy to carry every form of contraceptive approved by the Food and Drug Administration, including so-called morning-after pills, which destroy an embryo after fertilization. A pharmacy called Ralph's was owned by a Christian family. Opposed to abortion, they refused to carry abortifacients. If a woman came to the store with a prescription for such a drug, the pharmacy referred her to a nearby store that was happy to provide it. And there were 30 such stores within 5 miles of Ralph's, but to the state of Washington that was not good enough. Ralph had to provide the drugs itself or get out of the state. One more example. Consider what a member of the Colorado Human Rights Commission said to Jack Phillips, the owner of the now notorious Masterpiece Cake Shop, when he refused to create a cake celebrating a same-sex wedding. She said that freedom of religion had been used, quote, to justify all kinds of discrimination throughout history. You can easily see the point. For many today, religious liberty is not a cherished freedom. It's often just an excuse for bigotry, and it can't be tolerated, even when there is no evidence that anybody has been harmed. And the cases I just mentioned illustrate the point. As far as I'm aware, not one employee of the Little Sisters has come forward and demanded contraceptives under the Little Sisters plan. There was no risk that Ralph's referral practice would have deprived any woman of the drug she sought, and no reason to think that Jack Phillips's stand would deprive any same-sex couple of a wedding cake. The question we face is whether our society will be inclusive enough to tolerate people with unpopular religious beliefs. A Harvard Law School professor provided a different vision of a future America. He candidly wrote, quote, "The culture wars are over. They lost. We won. The question now is how to deal with the losers in the culture wars." Over the summer, the Supreme Court received 2 applications to stay COVID restrictions that blatantly discriminated against houses of worship, one from California, one from Nevada. In both cases, the court allowed the discrimination to stand. The only justification given was that we should defer to the judgment of the governors. So if you go to Nevada, you can gamble, drink, and attend all sorts of shows. But here's what you can't do. If you want to worship, and you're the 51st person in line, sorry, you are out of luck. Houses of worship are limited to 50 attendees. The size of the building doesn't matter, nor does it matter if you wear a mask and keep more than 6 feet away from everybody else. And it doesn't matter if the building is carefully sanitized before and after a service. The state's message is this: forget about worship and head for the slot machines, or maybe a Cirque du Soleil show. Take a quick look at the Constitution. You will see the Free Exercise Clause of the First Amendment, which protects religious liberty. You will not find a craps clause or a blackjack clause or a slot machine clause. Nevada was unable to provide any plausible justification for treating casinos more favorably than houses of worship. But the court nevertheless deferred to the governor's judgment, which just so happened to favor the state's biggest industry and the many voters it employs. Consider a case that came shortly after the Nevada case. The FDA has long had a rule providing that a woman who wants a medication abortion must go to a clinic to pick up the drug. The idea is that it's important for the woman to receive instruction about the drug at that time. The rule was first adopted in 2000, and it has been kept on the books ever since. A few weeks ago, however, a federal district judge in Maryland issued an order prohibiting the FDA from enforcing this drug any place in the country. Enforcement, he found, would interfere with the right of women to get abortions. Why? Because some women, fearful of contracting COVID if they left their homes, would hesitate about making the trip to a clinic. Now, when the judge made this decision, the governor of Maryland, presumably advised by public health experts, had apparently concluded that Marylanders could safely engage in all sorts of activities outside the home, such as visiting an indoor exercise facility, a hair or nail salon, and the state's casinos. If deference was appropriate in the California and Nevada cases, then surely we should have deferred to the Federal Food and Drug Administration on an issue of drug safety. But no, in this instance, the right in question was the abortion right, not the right to religious liberty, and the abortion right prevailed. In 1972, the comedian George Carlin began to perform a routine called The 7 Words You Can't Say on TV. Today, you can see shows on your TV screen in which the dialogue appears at times to consist almost entirely of those words. Carlin's list seems like a quaint relic. But it would be easy to put together a new list called Things You Can't Say If You're a Student or Professor at a College or University or an employee of many big corporations. And there wouldn't be just 7 items on that list. You can't say that marriage is a union between one man and one woman. Until very recently, that's what the vast majority of Americans thought. I wrote the following: I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools. That is just what is coming to pass. One of the great challenges for the Supreme Court going forward will be to protect freedom of speech. Of course, the ultimate second-tier constitutional right in the minds of some is the Second Amendment right to keep and bear arms. Last year, we finally took another Second Amendment case, and what happened after that is interesting. The case involved a New York City ordinance. The city makes it very inconvenient for a law-abiding resident to get a license to keep a gun in the home for self-defense. But the Second Amendment protects that right, and if a person is going to have a gun in the home, there's broad agreement that the gun owner should know how to handle it safely, and that the best way to acquire and maintain that skill is to go to a range every now and then. The New York City ordinance, however, made that hard. It prohibited a lawful gun owner from going to any range outside city limits. And there were only 7 ranges in the entire city. And all of these but one were largely restricted to members and their guests. There were other ranges that lay just outside the city, so why couldn't a city resident go to one of those ranges? The city really had no plausible explanation, but that didn't stop it from vigorously defending its rule. Once we granted review, however, the city suddenly saw things differently. It quickly repealed the ordinance, and it said that, on reconsideration, doing that did not make the city any less safe. In the place of the old ordinance, it adopted a new, vaguer one that still did not give gun owners what they wanted, but the city nevertheless asked us to dismiss the case before it was even briefed or argued. And when we refused to do that, the city was obviously miffed. 5 United States senators who filed a brief in support of the city went further. They wrote that the Supreme Court is a sick institution, and that if the court did not mend its ways, well, it might have to be, quote, restructured. After receiving this warning, the court did exactly what the city and the senators wanted. It held that the case was moot, and it said nothing about the Second Amendment. 3 of us protested, but to no avail. Now, let me be clear again, I'm not suggesting that the court's decision was influenced by the senator's threat, but I am concerned that the outcome might be viewed that way by the senators and others with thoughts of bullying the court. This little episode, I'm afraid, may provide a foretaste of what the Supreme Court will face in the future, and therefore I don't think it can simply be brushed aside. The senator's brief was extraordinary. I could say something about standards of professional conduct, but the brief involved something even more important. It was an affront to the Constitution and the rule of law. Our obligation is to decide cases based on the law, period. And it is therefore wrong for anybody, including members of Congress, to try to influence our decisions by anything other than legal argumentation. That sort of thing has often happened in countries governed by power, not law. A Supreme Court justice from one such place recounted what happened when his court was considering a case that was very important to those in power. He looked out the window and saw a tank pull up and point its gun toward the court. The message was clear: decide the right way, or the courthouse might be, shall we say, restructured. That was a crude threat, but all threats and inducements are intolerable. During my 15 years on the court, a lot of good work has been done to protect freedom of speech, religious liberty, and the structure of government created by the Constitution. All of this is important, but in the end, there is only so much that the judiciary can do to preserve our Constitution and the liberty it was adopted to protect. As Learned Hand famously wrote, "Liberty lies in the hearts of men and women. When it dies there, no Constitution, no law, no court can do much to help it." For all Americans, standing up for our Constitution and our freedom is work that lies ahead.